pleasant day, everyone. My name is Guadalquiver, and for today's topic, we will be going to tackle about the chapter 4 of legal aspect in tourism and hospitality, which entitled Law on Partnership and Corporation. So for the objectives, number 1, differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporations. Number 2, identify the requirements in the formation and dissolutions of partnerships and corporation. So for the contents, we have the introduction, law of partnerships, classification of partnership, dissolution and winding up of a partnership, the order of liquidation for a limited partnership, order of liquidation for a general partnership, law on corporation, and kinds of corporation. The tourism sector requires a strong foundation for legitimate business operations, and forming a partnership or corporation is a better choice. The Civil Code of the Philippines governs the law on partnership, while Batas Pambansa 68 Corporation Code of the Philippines governs the law on corporation. Law on Partnership, Article 1767. By the contract of a partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund, with the intention of dividing the profits among themselves. Classification of partnership. Number 1. According to the subject matter. Universal partnership. This type of partnership involves a complete sharing of all the assets and liabilities among the partners. It means that each partner is responsible for all the obligations and debts of the partnership. Another one is a particular partnership. In this type of partnership, the partners agree to join together for a specific purpose or business venture. The partnership is limited to that particular project or activity. Number 2, according to liability. General partnership. In a general partnership, all the partners have the unlimited liability, so it means that each partner is personally responsible for all the debts and obligations of the partnerships. Another one is a limited partnership. In a limited partnership, there are two types of partners, which are general partners and limited partners. General partners have unlimited liability, similar to a general partnership. However, limited partners have limited liability and are not personally liable for the debts and obligations of the partnership. Number 3. According to duration. Partnership for a fixed term. This type of partnership is formed for a specific period or until a particular event occurs. Once the fixed terms or event is completed, the partnership automatically dissolves. Responsibilities of partners. So general partners actively participate in managing the partnership and share both profits and losses, while the limited partners usually have a more passive role, providing capital but generally not involved in day-to-day management. Dissolution and winding up of a partnership. Partnerships may dissolve due to mutual agreement, expiration of a fixed term, death or bankruptcy of a partner, or other events specified in the partnership agreement. It also involves settling partnership affairs, liquidating assets, paying off creditors, and distributing remaining assets to partners. Order of liquidation of a general partnership. Creditors are paid first from partnership assets. Remaining assets are distributed among partners based on their respective ownership interest or as outlined in the partnership agreement. Article 1839. In settling accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary in the next slide. The liabilities of the partnership shall rank in order of payment as follows. So first, those owing to creditors other than the partners. or any debts owed to people or companies outside of the partnership are paid off. Second, those owing to partnerships other than for capital and profit, or any money owed to partners for things other than their initial investment or share of profit is settled. Third, those owing to partners in respect of capital, or the partners receive back the money they initially put into the partnership. Fourth, those owing to partners in respect of profits, or any remaining money is divided among the partners based on their agreed upon share of profits. Order liquidation for limited partnership. Liquidation follows a similar process to a general partnership, with specific provisions outlined in the partnership agreement governing the distribution of assets. Article 1863, in settling accounts after dissolution, the liabilities of the partnership shall be entitled to payment in the following order in the next slide. Those to creditors, in the order of priority as provided by law, except those to limited partners on account of their contributions and to general partners. Those to limited partners in respect to their share of the profits and other compensation by way of income on their contributions. Third, those to limited partners in respect to the capital of their contributions. Fourth, those to general partners other than for capital contribution. Fifth, those to general partners in respect to profits. And lastly, number 6, those to general partners in respect to capital. At this juncture, we will be going to tackle about the law on corporation. Section 2, corporation defined as an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or antecedents to its existence. Corporations are legal entities separate from their owners or shareholders, managed by directors and officers. They enjoy limited liability, meaning shareholders are typically not personally liable for the corporation's debt. Responsibilities of incorporators and officers. Founders or individuals responsible for initiating the process of forming the corporation by filing the necessary documents with the state. Appointed individuals who oversee the corporation's daily operations and execute decisions made by the board of directors. So for the formation requirements, formation typically involves filing articles of incorporations with the appropriate state authority, outlining key details such as the corporation's name, purpose, location, and structure. Bylaws establish internal rules and procedures for the corporation's governance. At this moment, we are now to tackle about the dissolution and winding up of corporation. So, dissolution of corporations may dissolve voluntarily through shareholders' approval or involuntarily due to regulatory violations, insolvency, or court order. Dissolution requires winding up affairs, including liquidating assets, paying off debts, and distributing remaining assets to shareholders. So for the winding up of corporation, corporate assets are sold or distributed to settle outstanding debts and obligations. Remaining assets, if any, are distributed to shareholders according to their ownership interest. So for the last part of this topic, which is the kinds of corporations, we will be going to tackle about number 1, stock corporation, a type of corporation where ownership is represented by shares of stock and the ownership rights and control are determined by the number of shares held. Another one is a non-stock corporation. Unlike a stock corporation, this type of corporation doesn't issue stock and is often used for non-profit or charitable organizations. Members usually have voting rights. So next is the corporation de jure. A corporation that has fulfilled all legal requirements for its formation and is recognized as a legal entity. Next is a de facto corporation, a corporation that lacks some legal requirements for formation but is recognized as a corporation by law due to actions and conduct that imply its existence. Next is a public corporation, a corporation whose shares are traded on a public stock exchange, allowing anyone to buy or sell its stock. Next is a private corporation, a corporation that doesn't sell its stock or on public exchanges and is typically owned by a small group of individuals or entities. Next is a corporation sole, a legal entity often associated with religious institutions where a single person, typically a religious leader, holds both the corporate and religious officers. Next is the eleemosynary corporation, a non-profit corporation that exists for charitable, educational, or religious purposes, often exempt from certain taxes. So next is a domestic corporation, a corporation that operates in the state of country in which it was incorporated. And lastly, the foreign corporation, a corporation that operates in a state or country other than where it was originally incorporated. So that is all about my report. I hope I deliver it clearly. Thank you for watching and bye.